We're going to change our topic. We're not going to talk about the DMA anymore. Okay, can I start? Okay. Thanks, everybody. Welcome. We're going to talk today about the DMA and market structure. I have a really very excellent panel for you. Let me introduce everybody. I'm going to do it according to alphabetical order. So first we have Jaime Gonzalo, who's here second to my left, and he is the COO of Aspiegel. And what he is really very expert on is independent app stores. Aspiegel is building an app store, and he's going to tell us about that. And then we also have, to my left in the G category, Jan Guzman, who is head of the digital economy unit at the Autorité de Concurrence in France. And Jan knows, has done a variety of digital projects within the French government, but we are particularly going to talk about AI and how that fits into our topic here today. And then Michael Koenig is head of unit Digital Platforms 2 at the European Commission. So he is part of the team that is enforcing the Digital Markets Act and therefore has to think about these questions of both compliance and whether the way firms comply impacts market structure and who is entering and all of the topics that we will cover today. And last but not least is Carol Mask, who is Assistant General Counsel at Microsoft. Carol comes to Bruegel quite often, which is very nice of him. And Microsoft has a really unique position in this landscape because Microsoft is both a core platform service in some cases, an incumbent and an entrant in other cases. And so that gives the company a very interesting perspective on these developments. So what we're going to do is first talk about app stores because that's just a really concrete, visible way in which the DMA is changing the structure of the market. We used to just have one for each platform, and now we are going to have more. So we will start with both Carol and Jaime on that topic, and then we'll move to a bit more the role of the gatekeeper, and Michael will take on that, and then we'll move to the future with AI, and Jan will take on that, and then I will ask everybody a few questions. And then at the end, we'll open it to the floor. So please, if you have a question as we go along, put it onto the Slido thing, or just raise your hand when we get to that stage. Okay, so that's the plan. Very simple. Carol, your turn. Thank you.
Thanks very much, Fiona. Thanks for having me. I'm pleased to be here. The DMA is a part of my work, obviously, on the compliance side. I'm a lawyer by training, not even an economist. So I'm feel very honored, actually, to be invited to this discussion and talk about market structures. My bread and butter is more how to comply with the law. And that was the main focus of our work. It's also the reason why I need to speak in my own capacity, because I'm neither a technician now thinking about what the opportunities of the DMA are in terms of technical opportunities, nor a part of the strategic thinking of Microsoft. So not representing Microsoft in that way. But obviously, in the broader discussion about the DMA now being enforced for a while, the gatekeepers having presented their compliance efforts, and a lot of discussion about the how of compliance, people want to see effects. Obviously, it's early in the process, and so far I don't say anything new, and will probably disappoint anyone who's expecting me to announce any great news of a new gatekeeper on the horizon, which we are competing with or others are competing with. But there is a shift, obviously. We see how the gatekeepers are trying to address the DMA and comply with it, and how that is moving the needle in terms of contestability and fairness. And probably the fairness aspect is the first one and the easier one to spot. And there are discussions around the different efforts that are being made to comply and whether they are ultimately fair or not fair. It's probably a discussion that will continue. What will take longer is to think about contestability, and I think that's what the topic is. There are big shifts in technology markets that are driven by innovation and technology change. And I think it would be overpromising what the DMA can do in terms of shifts in the landscape, these kind of seismic shifts which, you know, came from the internet, which are probably now coming through AI, where we still need to see how that's changing the landscapes, which lead to not only to technology change, but also changes in business models and creating substantially new opportunities. That's definitely too early and probably driven by other factors than legal developments. But where this evening of level plates and of evening of the playing field are playing a role there, we see already opportunities, and the topic you raised is around app stores. Looking at the app stores, don't think, and that's, you know, just a personal comment than anything, I don't think anyone is now going out and competing on iOS with building a general app store. Probably, you know, the company that's having on their platform an app store is best placed to offer an app store, address the customer's needs, probably also compete on pricing. And there is no real business model behind establishing a second app store. But when it comes to more specialized app stores, there's plenty of opportunity to think about. Gaming is a big area for that, where there is a specific audience which is interested in having a specialized app stores, and that are opportunities that are now facilitated by the DMA. We need to see effective compliance in that space to fully seize those opportunities. But definitely there are ways forward. So I think we need to set expectations to the extent, you know, politically they or in the broader public debate, there was more or to the extent there is more of an expectation of a big seismic shift as a result. But having this discussion here today about, you know, the opportunities that are out there, and discussions that were organized by the ECN and the Dutch Competition Authority before the summer, are interesting ways to look at you know, these opportunities. And maybe I close there and hand it to the next, or do you want?
Say whatever it is you know about the Microsoft App Store and what it's doing, just as a fact.
Yeah, so there is an Xbox specific store. We were trying to bring cloud gaming also to the mobile phones, and that's the opportunity which the DMA definitely opens. That's probably all I can say at this stage, as we are working through some of the announcements that have been made to enable that.
Can I use that store on either of my handsets? May I use that store right now? Can anybody use that store on an Android handset or an Apple handset?
It's not yet on the mobile phones.
All right, good. That's what I wanted to get out. Jaime, you're up.
Hello, everyone. It is a privilege to represent the small competing app stores. And I would like to take you on a small journey into what it is, how does it feel to run a small app store in in the current European Union and after the DMA. App stores are the epicenter of our digital lives. Every other service we use, every messaging app, every browser, all is downloaded and updated from an app store. So the DMA has to fix app stores. Now, to understand what is there to fix, I would like us to picture the digital markets like an Olympic stadium. App stores are athletes. So normally what the DMA tries to do is that all of these athletes, they compete in the stadium in the same conditions by their own skill. The problem is that one of the athletes owns the stadium. And until the DMA, in the case of iOS, the other athletes were not even allowed to enter the stadium. So the competition is not about if it's fair or not. You were not able to exist. Now, the DMA has made progress. Now the athletes can enter the stadium. In the Android OS, they could already enter the stadium. Does it mean that they can compete in a fair way? No. No. It means that they can enter, but it doesn't mean that the conditions are the same. There are 4 big elements that make that the athletes that own the stadium run in a faster lane than the others, have special equipment than the others. And I will give you some examples. The first one is pre-install. Both gatekeeper apps are systematically, by default, pre-installed in all the phones. Yes, when you listen to gatekeepers, they say yes, but also the OEM can put their own. Samsung can put the Samsung store in Samsung phone, yes. But what about the European app stores? What is our chance to be there? If you're pre-installed, it means that the user doesn't need to know you. They don't even need to trust you. You're just there. For us, we need to build awareness. We need to spend in trust. We need to spend in the effort of going somewhere to fetch us. Then there's the system security saying that we are a risk when we are not. A risk is unproven, etc. That's acquisition. Second point is the uninstall capabilities. Uninstall means different thing if you're a gatekeeper or if you're a third party. When someone clicks and install on my store disappears from the phone. When someone clicks on uninstall from Google Play Store, the store stays in the phone. Disable and yeah, whatever you want, disable, but it's there with all the data. So it means different things compared to who applies to. The third one is the access of apps. As you probably know, if you're using mobile apps, 96% of apps are free. Free, it means everyone can download them. They don't have an owner other than the developer. The gatekeeper is definitely not the owner of apps. WhatsApp belongs to Facebook, or to Meta, not to Apple. But those apps cannot be found outside the gatekeeper stores. Why not? Because it takes an effort to developers to put them in other places, because there's no multi-homing to these app stores. So effectively, if I use a non-gatekeeper app, I cannot find many of the apps. So there's a very big disadvantage. And the last one is the favorite of many expert lawyers, the core technology fee of Apple and the Play services of Google. These are elements that prevent the apps from work normally and that were not implemented by the developers. An app like Uber is meant to work normally and you can see maps. If you don't have in your phone Google Play services, Uber will not work. Lufthansa will not open. YouTube will not open. So there are components that belong to the gatekeepers that artificially block apps from being used as they were intended. So are we seeing progress? Yes. Now we can enter the stadium. Can we compete in fair conditions? Not at all. No, I mean, the conditions are still very abusive in favor of gatekeepers. Can we launch on iOS and so on? Yes, but there are commercial risks and other elements that prevent that we can dare to compete on iOS. On Android, can we do that? Yes, but as I said, there's still many things to fix. So our hope is that the DMA is not content with what they achieved until now. It was a very good starting point, but there's I'm not sure if it's a long way or not, but the intention of the DMA in terms of fairness and openness and competition and contestability is not achieved yet. There is no contestability as per today to the gatekeeper app stores.
Thank you. How many independent app stores like you are there? Do you know approximately about?
There are there are different types of independent app stores. There are portals of the internet where you can sideload apps. They are not app stores per se, which means that there's not a human team making an editorial work of selecting apps. They are just repositories. It's like a library. You can go and pick a book. So this is available. App stores mean that there's a human team making sure that they are secure at a higher level degree, that they make some curation, that they create categories for children or audience with disabilities, and they can offer some kind of essence. In that sense, not all the app stores are equal in terms of quality, same as not all the singers have the same talent. But yes. But among the top ones, I would say that there are on Android at least 7 that I would recommend that are safe at the same level as Google Play. This is something that is actually important. We got hypnotized by the feeling that gatekeeper app stores are more secure than non-gatekeeper app stores. There's no evidence of that. No one has ever provided any evidence that a gatekeeper app store is more secure than a non-gatekeeper app store. A third-party app store could very well be safer than the Apple App Store until Apple proves it otherwise, but they have never done. So this story of we are the safest, actually no. Actually, there are many companies out there that are better at security, that get less attacks or less malware and so on, and yet Apple doesn't allow these companies to implement security beyond, or Google is the same. So that's why App Store secure, at least 7. The problem of these app stores is the content, as we said. So would you be able to use them? Yes, for the apps that they have. Why I cannot download WhatsApp from that app store? Because Meta has to make an extra effort for all of these app stores in lack of multi-homing.
Yep. Yeah. Great, thank you. Okay, so that's one tangible piece of evidence about the DMA changing market structure. We have 7 or more entrants in app stores, and we have more poised to enter when conditions get a little bit better. But that's not the only thing that the DMA does. There's quite a range of things that the DMA does. So Michael is going to take us through a few other points about the impact of the DMA on market structure. Thank you.
Thank you, Fiona, and many thanks for the invitation. So indeed, I also should stress that I'm talking in my personal capacity here. You know that the Commission has a number of pending cases that touch directly upon the issues that we discussed. So this is also one of the reasons why I'll try to open the perspective a little bit, but we'll also say a few words on what we just heard. Opening the perspective in the sense that when we talk about market structure, here we were talking about third parties and what can happen as obligations are implemented. I just wanted to recall that the DMA legislator also explicitly included a possibility for the Commission to impose structural remedies on gatekeepers in case of non-compliance. And this was a very, very important point that was made by the legislator to clearly have this option. And in the process overall, we also saw the conditions for this to be able to be deployed actually lowered in a desire to really have this as an option. So you may know this is, of course, only triggered in the case of systematic non-compliance, which is presumed in case of 3 non-compliance findings within 8 years. I think here one also has to consider that this means any obligation, any CPS. Yeah, so overall, you already see that this may not be a too high threshold depending on how things go. Then there's a requirement of the gatekeeper position to be maintained or strengthened, extended. The maintained came also in later, precisely not to make it too difficult or to have to show that this has to go. And then the legislators were very keen on trying to bring this as much as possible on an equal footing with behavioral solutions. So that's why there is no explicit hierarchy in these provisions. But of course, we have the requirement of necessity and proportionality. And obviously, this is a much stronger inroad into economic independence. And therefore, has to and can only be deployed with care. Maybe a last point to stress, the way this is designed is as a remedy. So it's not a sanction, it's a remedy, which means that both the repeat infringement has to be linked or has to be able to be linked to a structural issue, and likewise the structural solution has to be shown also to be able to actually address the repeat infringement or going to the root of it. Yeah, and I think some elements, you talked about the stadium, this, are pointing to these type of ideas. So just to say, the tool is there. I think the requirements, one can say, there was an effort to make those hurdles not unsurmountable, but make this a realistic option, but under a number of circumstances. Again, we are early today. We are not in any opening of this to be deployed, but certainly something to be kept in mind when we talk about issues of market structure. Just to complement or to complete, there is also a prohibition on future acquisitions. So if you want, here we have tools that both look backwards on existing structures and sort of changing them, but also avoiding structural changes that may lie in the future with further acquisitions. So here the DMA really has a two-sided perspective. Then just a few reactions on the question, did the DMA trigger seismic changes or where are we? I mean, I would say it is a seismic change to say there is not any longer only one app store per operating system. I think that is, if you want, shaking up, really long-standing practices in a way. But then, I think for the effects, it is indeed early days. We are discussing still the modalities of these opportunities that the DMA is supposed to create. And I would also see this often more like a wave. So there is the seismic change at the beginning, but the structural changes come in a wave. And you will necessarily have front runners, and then others may follow, and they have to see certain examples. That may be in app stores, that may also be in interoperability for messenger services that I'm also looking into. So where adoption by some front runners will also create ideas, business models for others to follow. And this is not only on the side of the businesses, but we also shouldn't forget about the users, because they were used, as you said, over years of having just one app store. So I think we should not underestimate that there is also a huge element of user education and overcoming inertia on the user side that we all know from our own habits to make these opportunities work in the DMA. And I think we need several factors to fit together. Effective compliance obviously is one that we are very, very keen and closely monitoring, but several factors have to come in there. I should also say it is not for the Commission to decide who is taking up these opportunities. I don't want to take any value judgment on whether it is better that gatekeepers or other type of companies take up these opportunities. The effect on contestability, I think we have to see in the individual cases, but I think there is no overall value judgment in that way. But obviously, the objectives and the expectations also behind the DMA is to open opportunities for a broad number of companies, even if some may, due to their existing services, may be closest to step in one of these. But I think the expectations, of course, didn't stop there. And then maybe just let me close with one thought, which touches maybe a bit upon what you mentioned. Because when we talk about structural solutions or remedies, it always is based on some, should I say, perception or sense of a conflict of interest or a tension in the incentives that a gatekeeper may have when you talk about the stadium and the athletes in the stadium. And indeed, we have several instances and obligations in the DMA where there is a process required of vetting third parties that want to enter a stadium, be it app stores, be it, again, interoperability, be it data access, where I think there are sort of legitimate security considerations to say, like, well, we have to have reassurances that new players observe certain requirements. And the question is it for the gatekeeper to check those or not? And I think this is an element where we can combine certain elements and say, well, if in the compliance solutions maybe such type of vetting processes are outsourced to third parties, this is a structural effect without a deep structural inroad into company structures. But it may be a way which is a bit in between these hard notions to address some of these questions and bring more objectivity in these fields, and also then make the effective compliance more plausible. So this is just a thought, and looking forward to the discussion. Thanks.
Very good. Thank you. Thank you, Michael. Jan, you're up next. AI is what everybody wants to hear about. And the DMA doesn't officially cover AI, although, of course, once AI is embedded in services that are covered by the DMA, then it will naturally flow that way. So how are you seeing both the evolution of the AI space and then how it's going to match and fit into the DMA regulation?
Yes, thanks for the invitation, and usual disclaimer, I'm also speaking on my own behalf. Sorry. And the AI is and is not in the DMA because the DMA is technological neutral. So it focuses on services, and either there's AI or not in the services, and so that's how it will cover AI. The main example is a search, for example. You already have an example. I don't think maybe in the EU, but not at least in the US, for the new Google AI experience, AI overview. So you can already do search with AI. And the AI revolution also illustrates how competition law complements the DMA, because DMA is set on a fixed list of core platform services with do and don'ts. And competition law is more flexible and can apprehend any new technology, any new services. And that's why competition authorities all over the world are rushing to analyze, to understand this new revolution, because I personally think it's the new revolution like the web was 20 years ago. And so we don't want to be catch by surprise by these new evolutions. And that's why there's so many opinions by competition authority. We did our own that was published in late June. And it took us only 5 months. So it was a very quick study. And it was only done by 2 people. So we needed to do some choices, and we focused more on the upstream levels of the AI value chain. And we didn't look at the downstream level, the application of AI, because there's too many things. And we thought...
Quick question. So upstream means the foundation models, the first...
Let me just do a quick reminder of how we see the value chain of AI. Yeah, it should be a good thing. At the heart, at the middle layer, you have the models, the large language model, where you have a dozen or couple dozen of actors. So you have main gatekeepers, but also Mistral AI, LF Alpha, Anthropic, and so on. On the downstream level, you have all the application using AI. So for example, search, Copilot, ChatGPT, and so on. There's so many. All the new startups in AI usually are in the downstream level. And at the upstream, so higher than the foundation model, you have 3 key inputs for AI. And we highlight them in our study, and the high barriers to entry, because you need a lot of compute power. And we found that for the majority of firms to access the compute power, you need to use cloud. And where we also did a study on cloud computing that was released in June last year. And on the cloud, at least in Europe, but I think it's worldwide, you have a major role of the 3 hyperscalers that are AWS, Google Cloud, and Microsoft Azure. And so we see, and all of the people are also gatekeepers. You also need data, a lot of data. And again, gatekeepers, major giants, digital have easy access to data, mainly to first-party data. For example, Google has its search indexed, also Bing, Microsoft has it been indexed. And last but not least, you need a skilled workforce. There's few people around the world at the moment that know how to build this LLM. And so there's a huge competition among players to hire these people, and there's some concerns regarding that. And with new terms regarding acqui-hire, where some giants, digital giants, they don't buy the firm, they just buy the people. And we saw that with Microsoft and inflation, but Google and Amazon also did that. I just don't remember the people from which firms they hire, but it's a major concern around competition authorities. So that's for the value chain. And so we found that they high barriers to entry, but also digital giants have huge advantages because they have vertical integration, they have easy access to data, and all the gatekeepers are present at different layers of the value chain, and Microsoft and Google are present on all the layers from top to bottom. And so that raises concerns. It's not anti-competitive per se, but we need to pay cautions. And so at the end, the authority made 10 proposals, and one of them it's regarding model as a service, so MaaS. It's a new kind of cloud services, and it's kind of a platform where firms can access models. And so it's Microsoft Azure Garden or Google Vertex Garden, it's Amazon Bedrocks, and it could be the main platforms where firms access AI in the future. And as I think all of you know, cloud services are listed in the possible core platform services. And so we say that the Commission should pay attention to the MaaS and maybe should do a qualitative assessment of whether or not it could qualify as a core platform service. And so MaaS is both in the DMA and outside the DMA at the moment.
Do you think there's enough non-gatekeepers in the current AI infrastructure that will be, so I shouldn't say infrastructure, in the current AI environment, that we might see those new names when we use social networks or search or something in the future?
At the model level, yes. There's 20-ish actors, so since there's only 6 gatekeepers, there's plenty of room for other actors. But when you go one level higher, AI infrastructure, you only have gatekeepers almost. The non-gatekeepers is NVIDIA, but it could almost considered as a gatekeeper, like the new role it has acquired with this AI revolution. And so at the computing aspect, it's very concentrated, and you need so much capex to enter this market. It will be hard to compete and to have new actors emerge, I think, in this sector.
Okay, so that makes it sound like our services regulated by the DMA are going to have gatekeeper supplied AI. That's just how it's going to be, so that then we'll end up with the DMA controlling the nature of those services and wanting them to be contestable and fair. Is that fair?
Maybe, I don't know. I can't predict the future.
Good answer. Me neither. So let me then just keep going around the circle and ask Carol. So this is an interesting position for Microsoft, on the one hand, going into app stores, on the other hand, being a gatekeeper in something like operating systems, on the other hand, being a challenger with Bing that actually does exist, unlike the app stores, it's really there. And then the future with AI, we don't even know. So it's a very confusing landscape for one company. And I guess I don't really have a question other than how does that does that manifest itself? I mean, how should we think about it? How does anybody think about it?
Let me try to answer this non-question, and maybe it's more, again, a personal comment. I think large companies will continue to play an important role in the competition, even though the DMA is more focused on new entrants and not so much on the competition by gatekeepers. And that's particularly true for some of the infrastructure investments that need to be made. You have heard Microsoft, our president, Brad Smith, and others speaking about the AI access principles, trying to recognize the responsibility of large tech companies in providing that infrastructure, ensuring fairness, meeting societal responsibility when providing that infrastructure. I think that's, a discussion that will further evolve. It's not so much impacted by the DMA. I think the DMA has a particular focus on addressing particular concerns in particular areas, and that's, I think, the subject of this discussion. But there are further developments outside that will address issues that might arise, like the ones that Jan pointed at in the AI sector, or which are part of the French study of the AI sector.
I want to come back quickly to Michael's point about structural remedies being a remedy. One of the things I notice coming from the United States is that a structural remedy is just a remedy. It's not considered to be a punishment for anybody. At the end of the antitrust case, if the best solution is some piece of the business needs to be separated and independently owned and competing, then that's just something that the court can decide, and it's not considered to be especially punitive. I mean, the firm does get to sell the asset, for example. So that is very interesting to me, to see the DMA be set up with this kind of attitude as opposed to we're just trying to punish. And I did not think it was such an important part of the law when I first read the law, but now we have actually compliance issues. I mean, there are firms, there's already non-compliance investigations, and it does seem to me to be important as a tool, because if gatekeepers cannot manage to reorganize themselves to comply, then the commission has to have some tools to use to try to fix the situation. So this is really a bigger step forward than I initially thought when I first read the law. Is that a fair characterization?
Yes, I think definitely it played a role and a significant role in the legislative process in making sure, and we had quite a number. Of course, we discussed every obligation also in quite detail, but relatively speaking, it is true that this provision really took quite some attention, precisely in order to overcome this perception that there was some invisible barrier in Europe in relation to this remedy,
right.
because it was perceived as something beyond what was could ever be proportionate, and I think that is a process that I think the DMA this provision tries to make, that it is a remedy. Indeed, it is not a punishment. It should never be portrayed as that. It's a remedy to an intrinsic problem. We have clear requirements here. We have clear proportionality requirements. So it's not something that where the Commission will deploy shooting from the hip. That is absolutely clear. We are very clear that the consequences for companies are very severe. But at the same time, it should also not be somewhere completely out of reach. And I think that was a bit the objective, and we also see it like that. As I said, at the moment it's not on the agenda because we are dealing with a first potential non-infringement cases and final decisions. Procedures are still ongoing, so but we will definitely get there once these even numerical requirements are met. Then the questions will arise: what is the concrete context where this may be used? So I think that was the objective, to bring this more on the radar, as you said.
Yeah. So let me ask Jaime, suppose the stadium got sold off and was independent, and none of the competitors in the stadium owned the stadium. So what do I mean by that? That would mean that the Apple App Store would be spun out, and it would just be a third-party thing. And the Google Play Store, I think you put Google services into the operating system, but the store then is spun off and is its own thing. Do you think that would help independent app stores?
It would definitely help a lot, but we don't need to get to that extreme. Someone mentioned that the advantage of the big companies when the question of AI and so on is the vertical integration they have. It's enough with unbundling the core platform services. If they are not so intrinsically connected, if the athlete of the stadium doesn't have advantages over the other athletes, is enough. They don't need to sell or to split the company, just to give the same opportunity. I wanted to also comment, I know that the DMA is quite specific to, is quite unique as a legislation or regulation, but there's a lot of cooperation with other territories that don't have the DMA, like the US or like South Korea. There is one case happening in the US, in the San Francisco court, in which in December last year they declared Google Play an illegal monopoly. I'm not sure if that would apply within the European regulation, but that's what they are dealing. What's interesting about that case is what Epic Games is requesting as a remedy. Again, not a punishment, but as a remedy. They are requesting mainly a couple of things. One is the decoupling, the unbundling of the pre-installs of Google in all the Google phones, all the core platform services together with Android OS. The fact that Android OS comes as a package with Chrome, with Google Maps, with YouTube, with the Play Store, with everything into one single agreement, that makes the power of the athlete inside the stadium of Android impossible to beat. So first of all is decoupling all of those. Make the access of Google Play same access as all the other 7 stores I mentioned, and then let people choose. The other thing they are asking for is access to the Google Play catalog. What is inside Google Play for a period of 6 years, and then we'll see what happens. Why is that? It's because, as we said, the apps inside Google Play do not belong to Google, and they give an enormous advantage in terms of offer based on an artificial exclusivity that they never paid for. Google never paid for these apps to be there. It's not like Netflix acquiring movies or Microsoft with your cloud gaming catalog. In the case of Google, they just had the chance to occupy 99% of the market, and then developers had to open there. So what we can learn from those cases is the remedies that alternative app stores are suggesting as effective, not to change the regulation, but the interpretation that the Commission can make in terms of realistic and effective solutions that could really change the situation.
Thank you. We see this in video. I don't know if any of you have a service that enables universal search, but if there's a film you want to look for, at least for me, I can go on Roku and I can put in the name of that film, and then Roku tells me which services have it. Is it on Hulu or Amazon or Netflix or Apple? And then maybe I subscribe to one of those and I can go find it. So this is the kind of thing that would help with locating your app, because otherwise you are looking in lots of different app stores and that might be somewhat tedious. Yes, so varieties of app stores. Does anyone have a suggestion for what? So I think Carol is right, going in and saying, I'm going to be exactly like the Google App Store, just smaller and not as convenient, is not a good business model. But coming in and saying, I want to do gaming and I will be a specialty store, or I will have children's content, I think these kinds of specialty ideas are quite possible. So if anyone on the panel has a favorite, I'd be interested in hearing that. The audience can think about it too. Anything you would invest in?
I can give an idea, but that's because that's how the digital markets work. There are several formulas that enable competition against a dominant player. One of them is exclusivity in content. Another one is tailoring or higher editorial, more discovery rather than browsing. Another one is cheaper prices and better offers.
Yep.
Another one is more friendly user interface. Maybe vertical video format becomes popular versus horizontal video format. The same could happen with app stores. There's new trends happening all the time. There are games and apps that are now, they don't need touch screens, but they are just move with your eyes, for example, so more comfortable ways of playing. I'm talking about disabled apps for now, the apps for disabled audiences, but they can be applied to other things. So there are many ways to differentiate your product, but you need to compete for that. You need an entry level. So after that door is open and everyone can compete, there's a lot of innovation to be done. At the moment, the innovation is to survive. So we cannot even explore all of those options, and the users cannot enjoy them. Even if there was one comment, sorry, about users are used to use one app store and so on. Look at users 20 years ago were used to linear cable TV, and now there's video on demand. And if something is good and answers to the needs and adapts, the speed of adoption, how fast people change from SMSs to instant messaging, it was almost overnight. So I don't have any fear on adopting new technologies and having choice, as long as there's a standard of quality and security and so on, but this can be implemented. And at the moment, those are controlled and dictated by gatekeepers.
Very good. Audience, does anyone have a question that you would like to ask the panel? Don't be shy. Yes, go ahead. I think there's a microphone coming. And maybe just give your name and affiliation.
My name is Igor Ramaj, and I work at a consulting company called Inline Policy. I have a question for Mr. Koenig. I hope I pronounced that well, and for maybe Mr. Gutmann. There's a growing literature from academics and also from enforcement authorities on how self-learning algorithm will affect market structure in the digital world. And actually, I think I've read a 2019 a study from the German and the French competition authorities on that topic. And unless I'm mistaken, I think the DMA does not really address such outcomes presented by self-learning algorithm, with one important step, I think, where the DMA permits enforcement authorities to require information on algorithm. But according to the literature, even though there are mixed views, these self-learning algorithms could have a tremendous impact on digital market structures. And so I was wondering, is the DG Comp considering a new legislative act to maybe complement the DMA on making fair competition in digital markets?
Thank you for the question. I think we first have to probably delineate exactly what we're talking about when you talk about like self-learning algorithms. We touch upon probably AI features already. So this is the first part which we probably have to look at. And the secondly is also what are the concrete concerns we're looking at? Because the DMA is very much driven on practices and problems, and then indeed the technology behind may not be relevant. So if we talk about algorithms, I mean, the first thing that comes to mind is self-preferencing. Yeah. So whether this self-preferencing is happening because of a twist in the algorithm or because the self-learning algorithm, again, is biased in a way, towards bringing up more the gatekeepers' offers than others, I mean, we are still in the range of self-preferencing that can be captured by the DMA as it stands. So I think we have to be very specific on what may be new edges, new issues. I think AI generally is a much broader discussion, which we have to have. You said some parts are, as long as it's embedded in existing core platform services, the DMA applies. When we talk about cloud, you already pointed to the fact, is there a case for bringing cloud services into scope? So it's more a structural one. Then we have all the questions on how are the new relationships in the AI field to be seen, which are not really visible changes in market structure, but the effect is the same if, you know, companies or the majority of the employees are sort of transferred between undertakings. So I think, again, we have some solutions in the DMA, but it is clear that the DMA is not a remedy for all of the issues that pop up in these new technologies. There are also some flexibility mechanisms in the DMA, I should stress again, like in Article 12, where we can amend obligations in a pretty broad way, I would say, on a if you want, short track legislative change, which we call delegated acts. So we don't have to go through a full-fledged legislative process if you want to adapt the existing provisions in, for example, extending them to other core platform services or changing some of the conditions under which they apply. So I think that also gives us some space to react. But obviously, there may be completely new dimensions and new issues where, yeah, I think now going into a new term, the new teams, both in the Parliament and the Commission, may have food for thought.
Thank you. And I think I'd like to turn to you, Jan, to ask a version of the same question. Let's imagine that the new commission is a little bit tired of legislating about AI, but yet, and the DMA is designed for platforms we understand, to say they're entrenched, nothing's happening, we understand that, so we have to open up access to business users. Is your forecast that we've got a pretty limited number of players upstream, so we can kind of conclude that we're ending up in this very entrenched market structure, and that therefore one way out would be for the Commission to study AI under the existing DMA, add it as a core platform service, and then business users, the 20 you mentioned, on top of the infrastructure could be protected and more could come in because they would have some rights to access the core platforms. Is that a vision of the future that makes any sense?
I don't think so. I don't think you can put AI in the DMA because AI is too wide. Same as in my opinion, the cloud services. Cloud services are in the DMA, but they are too heterogeneous. There's IaaS, PaaS, SaaS, and all have different characteristics. And so there isn't one rule fits all for all this category, and I think it's the same for AI. And so we need to focus on certain aspects. And a concentrated market is no guarantee for a non-competitive market. For example, in the AI chips, there's one foundry that is TSMC in Taiwan, but everyone has an agreement to use the same foundry, and since there's a fair entry from other competitors, it's still working, and so the costs are driving down. And NVIDIA is very dependent on TSMC, for example. They don't build their own chips, they just do the design. And maybe we could have the same thing on the computing power. If we've only 4 or 5 actors, but there's competition and there's no cartel, it could work. And on top of that, all the AI players could thrill and could develop, I think. And maybe maybe we need regulation on cloud computing, or maybe not. And if we need, maybe one comparison is to the telecom sector, where we imposed regulation on the backbone, on the telecom, on the local network, for example. So that's one way to think. But there's no good number of AI players on the large language model. So I don't think we need to protect the players. We just need to ensure that there's enough players and they can compete on the merits. And maybe just to touch on the questions about algorithmic collusion, since you mentioned the joint study from the Autorité and the Bundeskartellamt, we highlight 3 main cases of algorithmic collusions, whether it's with traditional algorithm, it must mean something, or AI algorithms. First, it's just a mean to put an agreement into effect, and so there's nothing new under the sun. Second, it's kind of a hub and smoke schema, and now we have a very good ongoing case in the US with a real page on the landlord markets, where we have one player with this algorithm that was collecting all the data from the landlord, and so it's still ongoing, but I think it's a very good illustration. And the last one is where algorithm self-learn how to align price, and so there's comparison to parallel pricing. And on this specific, maybe we will need to change the regulation of the legislation in the future if it becomes a problem, because I'm not sure that it's in the interest of the firms that to delegate all its pricing strategy to an algorithm it doesn't understand.
Yes, but we are seeing some danger signs, and I think the law is not clear, so I agree with you. Probably there's going to need to be an update. I wanted to take the last 5 minutes just for current events, because it is very exciting. We had today 2 rulings from the top court in Europe with wins for the Commission. I don't know, Michael, if you'd like to make a short comment on those. I mean, I will just say that Google Shopping began in 2009. So it is 15 years after the start of that case that we get its final resolution. And I think that demonstrates why acts like the Digital Markets Act are useful, because they're ex-ante regulation that maybe the first few cases will take a long time because firms will appeal till they're sure what the law really means. But once we know what it means, the idea is that it does not take 15 years to get a resolution of something under the DMA. Is that a view that you think is held generally in the Commission, that in the end this should be faster than using antitrust?
Yeah, so maybe let's say like 2 reactions. The first reaction is that we are of course always pleased if we hear the court taking the view that we did a serious and a proper job in doing our investigations and decisions. So that is of course very reassuring. The second part on the effect itself, we all know that the DMA also in substance was inspired by some of these cases, and some of the obligations were designed being inspired by those obligations. So obviously it's also reassuring and creates, let's say, stability in the DMA implementation, that some of the root cases now also have been confirmed, I would say. And in terms of timing, well, I think it is not a secret that one of the drivers behind the DMA was to say, well, we want a more effective, and that means also faster tool to address some of the most egregious practices that have been observed over time. And that's why we design very specific obligations, so that we can be very specific. We have a system of designation which brings very quickly clarity about the companies in scope. So I think that is definitely behind it. At the same time, I also wouldn't say that this invalidates the value of antitrust enforcement in any way. We always said, the DMA is for specific issues that we could identify, but there's a lot around it, and things are evolving. And as much as we talk about flexibility and possible amendments, there is a need for the flexibility that we only have in antitrust.
Absolutely. Carol, any comments on the decisions today?
No, I can't really comment. There's actually a lot going on. I think it's showing that the courts are effective. I'm always a little bit hesitant chiming in, this is taking too long. It was a big lift. It's a big development. Getting to this point wasn't an easy one, and antitrust has never been, obvious. It needs discussion. There can always be a discussion whether 15 years is too long. In fast-moving markets, you might want to see results and changes faster taking place in the marketplace. That's the purpose of the DMA. But at the same time, there is, value in review. I still see a lot of value in, traditional antitrust, because it is a more flexible tool to adjust to changes, and I think the Commission emphasizes that role. It's easy to point to 15 years. It's not the rule. It's only a few cases that make it there. There are cases that are solved much faster. So it's, wanting to
Maybe
put
it's
that a
an
little bit
exception.
into
Yes,
perspective.
not the average. That's fair. That's fair. Jaime, anything you want to add about these cases?
Well, actually, we small players have a fear that we have been so long playing these situations with the antitrust mentality that our instinct makes it difficult to adapt to the DMA opportunity, even for regulators. In that sense, we're a bit surprised that we are already 6 months after the compliance deadline, and there has not been many cases saying, okay, this is not compliant, and you have to prove it. There are proceedings ongoing, yes, and there was a workshop in terms of self-compliance from the gatekeepers, but we should, I think you have the power and the opportunity, you as a commission, not you yourself, to say, well, we don't think that this, you have been designated for a reason as a compliance service. We don't think you're compliant, so prove us wrong. And then we can, and then if they prove they're wrong, it's fine. You can say, fine, you convince us or not, you are not compliant, and therefore there's something to be done. We would expect something more agile, at least in some of those cases. So hopefully those proceedings that are ongoing will not take too long.
15 years.
Well, or I don't know, I'm not sure, it's not about make a compromise, but we would need something fast, relatively, in terms of saying, okay, because some of them are quite obvious. As we said, you can just take the example of the stadium the athletes. How many things do not allow athletes to compete in a fair way? I think some of them are very obvious. So those could be said directly, okay, this is not compliant, that's it. But maybe it's much more complicated. I'm, unlike Carol, I am a technical background. I'm not a lawyer, so for me, everything is very mathematical, and mathematics are exact. Probably in law is much more complicated. So I apologize for technical comments.
Jan, did you want to comment on current events? Would you close us out?
I have also technical background. So I'm not a lawyer, but now 15 years, it's a too long time, I agree. And maybe you didn't mention, but today is a victory, but we have a kind of defeat on Article 22. And it was something that exists, albeit imperfect, but to assess the power of gatekeepers and how they could acquire some potential competitors. And so on this aspect, new legislation will be needed, and the authority issue statement taking into account this new new horizon, and say that it will explore new possibilities on how to tackle this kind of
Let me just make sure the audience knows what you're talking about. Illumina Grail was decided by the court against the Commission, meaning that it is now more difficult for the Commission to get jurisdiction over mergers where the value of the corporation being acquired is quite big, but it doesn't have any turnover. So imagine you are inventing a cancer test and you will sell it in 2030. You are a very valuable company because everyone wants to solve cancer cure, but you have no revenue today. And this kind of merger is now, I don't know what the strategy is for the Commission to try to get jurisdiction over it. And in digital, it's a big problem.
There's an obligation for gatekeeper to inform the Commission of acquisition like that. And I think it was thought with this Article 22 in mind that it could examine under, and now this part is gone. There's still the obligation to inform, but okay, what do you do with this information?
What do you do? Good. All right, so we stay tuned for future developments in the DMA. There's a lot to look forward to, and thank you very much to the panel for your great remarks.